we're going to jump right back into the family law stuff. And I say stuff because mediation is really broad across all sectors of the law. We do a lot of mediations for our personal injury clients. The courts, actually require you to do that now under court orders. Whether they're successful or not, we feel like they're very successful in the personal injury sector because it allows people to actually maintain control of their case, make a decision. You don't have 6 members of a jury telling you whether you're at fault or not at fault, whether you recover 0 or not. And so mediation for us has been going on for quite some time, Rob, and it's been very successful over the several decades that I've been practicing. But family law, I think over the last probably 10 years, does that say, for
fair, yeah.
10, 15 years, they've been pushing more mediations for the family law now. And so explain what a mediation is in the family law and what it costs and how you get paid.
Well, in family law sectors, I mean, mediation is required by every county in the state of Florida. All 67 counties require you to go to mediation, and I think I mentioned the numbers earlier about having something like 3,000 open cases of family law. The courts want you to settle, and the best way to facilitate that is to get you together and try to get you to an agreement. I actually am a certified mediator for family law as well, and I can tell you, most of them, when you get in a room, they're going to tell you that they don't work for the attorneys. They're there to work for you, the clients, to help you guys, come to an agreement. A lot of times it's outside the box thinking. It's pushing a button here, pushing a button there, trying to get somebody to push or give a little and compromise on where they need to be. Here in Bay County, we have an alternative dispute resolution program at the courthouse, which makes it very, very affordable for those lower income families or going through that type of situation. I believe if you make a combined income of less than $100,000, you can, it's $120 per piece to go to mediation. If it's a combined income of less than $50,000, I believe it's $60 a person for doing that. And I've also found that the local mediators around here, the private ones, are very reasonably priced. And generally speaking, they don't have any skin in the game, and that's the way it's supposed to be. Right. But they want you to, the word gets out. They want you to do well. They want you to settle the case because that's good word of mouth and business for them.
So one of the goals of the court is you got yourself into this mess. Mm-hmm. You guys come together and get yourself out of this mess. and I mean, that's kind of a broad way of saying it probably, but or a loose way of saying it. But like in personal injury, it's something that's actually, discussed, I believe, in every mediation I've ever been in, is that person who is injured is making the decision, right, okay, with the attorney's guidance, but they're actually still in control of that case about what happens.
Right.
And so, just the example with the family law stuff, you got yourself into this, you've got great lawyers that are representing you hopefully on both sides, and you've got a neutral party mediator, and the courts are pushing this to say, take responsibility of this issue. Don't have me as a judge have to rule on something that I'm looking at a court file here, and I don't know how it affects your work schedules or your families. And you guys, if you can figure it out now in mediation, chances are you're probably going to figure out how to co-parent later. And if you don't have children, at least come to some resolution about what you're willing to accept and give away if you're just going to get a simple divorce.
Well, and what you have to remember too is during a divorce or even in a child custody issue, mediation may be the first time they've had a real interaction with each other in weeks, other than little girls got soccer practice at 6, good luck, or things of that nature. They get to come together. Now a lot of them are done these days over Zoom, and so that it could be less invasive, but also it takes a little bit of the anxiety out of it for the parties.
I would have to say it probably gets a little heated in person.
It can be. The way these things usually
start.
Thank
goodness for Zoom now.
And the old way these things used to start was they'd start in the same room, and if you could get through the first 5 minutes and the opening from the mediator, you were doing good. But even then, they would break off into what they call breakout rooms and separate them. And because at that point, you really, you could talk to your attorney, you take a deep breath, and your attorney or the mediator could calm that person down and kind of assuage fears and say, look, just calm down, take a deep breath. This is for everybody's best interest that we do it this way.
One thing good about the mediator, that person is neutral, and whatever you tell that mediator is confidential.
Absolutely.
And you can tell the mediator, you can share this with the other side, but if you don't say that, typically speaking, the mediator is not allowed to even discuss that.
That's correct. And generally speaking, most mediators that I work with will tell you, hey, if there's something, that is, they'll tell you, hey, common sense wise, you call the person a jerk or something like that. I know not to take that over to the other room. Right. But if there's something in specifics that you don't want the other side to know, whether it's a negotiating tactic or it's something that you just want to keep close to the vest, you tell the mediator, look, tell them this, this, and this, but not this. And of course, you mentioned confidentiality. Everything in mediation is confidentiality, and the reason they do that is they don't want you coming back and throwing stuff in people's face
Right.
in the courtroom, because the judge doesn't know anything about mediation. He gets a piece of paper that says, impasse or agreement, and that's about it, or continued.
Rob, from the time that you file a divorce, how quickly can you get to mediation?
The quickest you could possibly get to mediation, if you've done everything, probably is 45 days.
Okay. And that's, you got time, after you get served with the complaint to, respond. So that's 20 days. And so, yeah.
Well, and they tell you when you're being taught to be a mediator, and the mediators will tell you it's kind of your last chance to self-determine what's going to happen. And there's a degree of that to it, but at the same time, in any family law case, just like in any court case, you could settle at any point.
At any point, right.
At any point. You could settle the day you walk in. You could settle the day of court. I settled one in November last year where at halftime, so to speak, or at lunch break, the judge looked at us and said, maybe you guys got to go outside and talk for a minute. And so we did, and we walked outside and settled it. So, once again, it's like you said, you have control of your case. You're the decision maker in your case if you're the party. The mediation is just a tool to kind of help you, make a decision or make you more comfortable with it, or try to come to a meeting of the mind, so to speak.
Right. I got you.